से पैसा देते वो.
Serial number 13, the Union of India versus Manish Chandra Roy for the petitioner Sri Sujit Kumar Sinha.
Yes, sir.
In this case, सर कोई 11 में करना था, 13 में करेंगे तो बहुत अच्छा. 13 में है कि ये लोग कम मार्क्स वाले का बहाली हो गया. हमारा कहना ये ओबीसी कैटेगरी के है, ओबीसी कैटेगरी में इनसे कम नंबर वाले का किसी का अपॉइंटमेंट नहीं. डायरेक्शन हुआ स्पोर्ट इंस्पेक्टर बात की है, हम बता रहे हैं.
The court is giving instruction.
हम कर सकते हैं.
जी.
My lord, page 15 and 19 is the impugn order. I have given a very short synopsis, my lord.
OA is on which page?
Page 17, 18, 19.
OA begins from the page, my lord. OA begins from the.
Please go through para 4.
Yeah.
Para 4.
Of the impugn order, my lord, na?
Yes.
But we have gone through the pleadings and heard the argument made by the counsel from both sides. It is accepted that fact that the applicant secured more marks than the two candidates, the private respondents, who have, my lord, obtained less marks than the petitioner, my lord. And therefore the direction was given. Yes. The non-joining subsequent resignation of two candidates.
Mike.
The only reason that was mentioned in that time of argument by the London counsel for the respondent was that the applicant has been given the benefit of age relaxation on the ground of being an OBC candidate, and that's why he could not be considered against the other vacancy. This is the prima facie illegal since age relaxation and marks on the merit are unconnected. It is all more irrelevant since that did not anyone that the applicant even otherwise qualified for age relaxation. Any vacancy which occurred should have gone either to the candidate belonging to the same category, or in the absence of any candidate available in that category, the person secured next highest marks in the combined merit list. In that logic, claim of the applicant definitely superior to the respondent. They have not only belonged to the reserved category. They are not only not belonging to the reserved category, they also secured lesser marks than the applicant. And in that situation, we find full justification granting the prayer of the applicant and direct the respondent to offer the appointment as assistant coach taekwondo in pursuance to the notification published in so-and-so. The answer to this question is, my lord, that the merit list is attached. That is at page 21, Annex 3, my lord. This is the first, my lord. Serial number 1 to 12 is the candidates who have been appointed on merit. This is the list.
21.
Page 28, my lord, Annex 3. 1 to 12 has been Annex 3, page 28.
Where is this applicant, Manish Chandra?
Manish, I will show, my lord. This is the first 1 to 12 is the merit list. Thereafter, OBC category is 1 to 5. Thereafter SC category 1 to 3. Thereafter ST category 1 to 3. The wait list is indicated thereafter, my lord.
Where is Mr. Manish Chandra?
Yes, Manish Chand. Manish Chand is OBC category in the serial number 7 in the wait list. He has secured 39.90 marks. Serial number 7 in the wait list. Serial number 7 in the wait list.
How come the learned tribunal says that he topped the list?
And my lord, the
Page 29, your lordship.
se-
Your lordship, at serial 25, above the private respondent. At serial 25, page 29.
No, cutoff percentage is 42.60.
cutoff marks for
42.6.
yes
The last match.
in the that was the first list, and thereafter the two vacancy occurred.
Sir, 1 second. Take page 28.
Yes.
The item number 12 is Neeraj Kumar.
Yes, my lord.
He has secured 42.60.
Yes, my lord.
He is the last person.
Last person in general.
General.
Yes.
All right. Now take OBC. First, Dwipen Burman, who has secured 56.20.
Yes.
He should have been accommodated in the general category. Why he has been shifted to OBC?
Even
He has secured more marks than the last cutoff percentage person.
even 53, 51, 46.
All these persons should have been accommodated as against general category.
My lord, there was one thing further, my lord. The persons who have got the age relaxation in the OBC category as well as the working experience, they have to be selected in that category only.
Now show us from the material that Dwipen Burman, he has been extended age relaxation and experience qualification.
उसका तो रिकॉर्ड अभी नहीं है.
Without that, how to determine? The office must record, no, in the file. These are the persons, though they have secured more marks, but still they have been given age relaxation. Therefore, they should be accommodated only against OBC category. Where is the recording?
That date of birth is indication, my lord.
Huh?
I will ask it from the office, my lord. The details we will ask from the office, my lord.
Just take down perusal of Annexure 3.
109.
Merit list. Taekwondo.
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 It is evident that last selected candidate under general category dash Neeraj Kumar has secured 42.60. On the other hand, OBC category first 4 persons have secured more than 42.60. Similarly, under SC category, Thomas Sethi has secured 59.40. Under ST category, Chandra Basumatari Mandal has secured 46.30. All these persons should have been accommodated under general category if the cutoff percentage is 42.60. Please stop. Today, Land Council for the respondent, petitioner submitted that such of those persons who are in the OBC, SC and ST category and more merited than the cutoff marks have been extended age relaxation and some other concession has been given. If it is so, the concerned selecting authority should have recorded that who are all have been extended age relaxation and any concession in the process of selection, so as to contend that even though such of those persons who are more merited than the last selected candidate under general category are not entitled to have a position in the general merit list. In this regard, counsel for the petitioner intends to produce the necessary material which was stated to have been recorded by the selecting authority. Release this matter after 2 weeks.
Let 4 weeks time may be granted.
All right, 4 weeks. Please don't take further time. If you don't understand, keep your officer present who is conversant with the matter.
लेटर आज ही बना दीजिएगा. Don't wait for the order.
Serial number 14, Prabhanjan Kumar Gupta versus the Union of India for the petitioner Sri Tapeshwar Sarma.
Yes, sir.
I have gone through record, my lord. As per railway servant
Records available.
discipline rule.
Record आपके पास आ गया है.
जी, railway servant discipline rule, my lord, and section 11, my lord, two type of for the minor punishment, my lord. My lord, after submission of report by the authority, my lord, issue so called notice, and after submission of report, my lord, withheld 3 increments for cumulative effect, my lord. For this incident, my lord, the petitioner is entitled for withheld 2 increments, my lord. Order was passed in 2015, my lord.
Which is the relevant rule for imposing procedure for minor penalty?
Minor penalty as per my lord, rule 9, before making any order imposing on any railway servant any.
No, rule 9 is related
rule
to major
11, my
penalty.
lord. Rule 11. May kindly see the rule 11.
Rule 11.
Procedure for imposing minor penalties.
Your charge memo is in respect of rule 11?
My lord, after submission of inquiry notes before the authority, my lord, authority.
Sir, your charge memo is in while invoking rule 11.
Rule 11, my lord.
Show us from the charge
9.
memo. Show from the charge memo.
Charge memo I have already issued, my lord.
Sir, where is the charge memo?
Annexure 3, page 23.
No, that is the reason. No, that is the reason. They must start in the major. Rule 11, they have to invoke rule 9. Finally, they can take a difference. But once they have invoked rule 11, they have to go to the 9.
Where is the charge memo?
Annexure 3, my lord.
Page number?
Page 23.
Huh?
Page 23. The same rule said by my friend is not mentioned in the charge memo.
Where are 23?
This 13/4/15.
G.
Yes, my lord.
Mention of rule 11. officers they come to the bench.
This is just a pro forma. They have saved themselves. They only say under the railway servants was. Rule 2 includes both 9 and 11.
My subject to the provision of sub-rule 4 of Rule 10, no order imposing any railway servant any of the penalties specified in clause 1 to 5 of sub-rule 1 and clause 1 and 2 of sub-rule 2 of Rule 6 shall be made except after imposing the railway servant in writing of proposal to take action against him and the imputation of misconduct or misbehavior on which is purported to taken and giving him a reasonable opportunity to making such representation as he may wish to make against the proposal, holding any inquiry in manner laid down in sub-rule 3 to 19 of Rule 9, in every case in which the discipline authority is of the opinion that such inquiry is necessary, taking of the representation, if any, submitted by the railway servant under Clause A, and the record of inquiry, if any, held under Clause B into the consideration, recording of the finding of each imputing the misconduct or misbehavior, consulting the Commission which such consultation is necessary, notwithstanding anything contained in Clause B of sub-rule 1. In a case, it is proposed after considering the representation, if any, made by the railway servant under Clause A of the sub-rule of withhold increment or pay, and such withholding of increment is likely to affect adversely an amount to pension payable to the railway servant, or to withholding increment of pay for the period exceeding 3 years, or to withholding increment of pay with cumulative effect to any period. Any inquiry shall be held in the manner laid down in the sub-rule 6 to 25 to Rule 9 before making any order imposing the railway servant any such penalty. For this incident, my lord, we have been entitled to hold in 2 increments for 2 years, my lord.
He dragged it up to 500 meters.
Who has given a report? Whether is he not entitled to be examined, cross-examined?
In that case, that is the major
But if he is disputing that I applied brake, but it could not be something like that.
Where is your defense? Where is your defense?
My lord,
Where is your defense against this charge?
my lord, actually, my contention is before punishment, preliminary inquiry should
Sir,
have been done.
please come to the fact. There was a charge
Before
against,
punishment, my lord.
There was a
And-
charge against you that you dragged the wagon for 500 meters. What was your defense?
My lord, preliminary inquiry was not done before charge issuing of charge memo.
Sir, what was your defense?
Under which provision of preliminary inquiry is required to be held?
My lord, so far
Preliminary inquiry is required to be held under which rule?
in the rule I have not seen, my
Then
lord.
how can you make such submission? We have to go by rule. Rule 11 does not speak of holding of a preliminary inquiry. Only issuance of show cause notice and a reply
But
thereafter to
the
proceed in
allegation,
court.
allegation
Where
level.
is your reply to the charge, the show cause notice?
My lord, so cause
First
notice,
show cause notice.
so cause reply is page Annexure 5, my lord.
What you are reading?
My lord, it is written in Hindi, my lord. I have stated in my show cause.
No, that is the reason. Some mechanical, technical person must have given report, no?
He says that if it is delayed, it cannot be dragged for 500 meters. That is
So it is a disputed issue. Then who the technical person must give report, no?
Any technical person
Where
has
is-
given report?
any report?
My lord.
Who has given report?
Report,
That,
my lord,
the-
supervisor
It
of
was
the
dragged for 500 meters. Who has given the report?
five-man committee, my lord. He is the supervisor,
Committee?
head supervisor of the technical team, my lord.
Which annexer?
Annexure, my lord. I already annexed in my counter affidavit, my lord.
Annexer?
Page 13, my lord. Joint notes of the
Page 13.
13, my lord.
That copy was made available to him
My lord, already available.
along with the show cause notice.
Yes, my lord, already.
No, read from the show cause notice.
Before show cause notice, such a copy was not given.
Already joint notes.
Sir, show me from the show cause notice that
My
you have
lord.
provided a report of the committee.
So the entire application is based on the committee report. Committee report copy should have been made available.
Report,
It is disputed that it is not possible to drag for 500
That is on, my lord,
Sir, along with the show cause notice, have you given or not?
already given, my lord.
Don't say already given. Along with the show cause notice, you are required to give. We'll come back.
My lord. हाँ सर ओके हाँ
गिवन नहीं ना फोकस के साथ दिए कि नहीं उतने जाना
दिए
स्टेशन और शोकसबा में देखे ना लिखा होगा
है
कहाँ लिखा
आज दिनांक 14/3 बजे पार्लर में कार्य के दौरान लापरवाही पूर्वक तंत्री की जाने में 2 किलो बेहतर इस प्रकार आपके रेल सेवा आचरण नियम नियमों के उल्लंघन का उल्लंघन
नहीं इसके साथ वो कहाँ दिए रिपोर्ट
रिपोर्ट टीवी लगा हुआ
ओहो नहीं ना शोकस के साथ शोकस नोटिसवा में लिखा है कि रिपोर्ट संलग्न की जा रही है फिर साहब उठ गए अपन पूछते
फिर 7 के बाद 8 के बाद शुरू कर लेते ग्रुप से शुरू हो गया फिर अभी चल रहा है 18 चल रहा है 14 हुआ 16 हुआ फिर 18 हुआ टिकट
पानी वाला नहीं किया कुछ नहीं और तो मैं
8 के बाद कोई 9 था 8 किए हैं 8 के बाद कोई दूसरा
होगा आप में
मुझको तो नहीं मिला आपका रिपोर्ट है ना है एनेक्चरी इज द रिपोर्ट
हाँ नेक्स्ट 3 में देखिए
काउंटर के एनेक्चर 3
नहीं आपके पिटीशन में लगा हुआ है नेक्स्ट 3
एनेक्चर 3 तो आप पनिशमेंट ऑर्डर
नहीं नेक्स्ट 3 देखिए ना पेज 23 पर
वो
आपके
तो
अधीन
शो को
आरोप, हाँ वही तो कॉल आरोप
ये तो चार्ज में वो है।
हाँ तो आरोप संलग्न है। वही है आरोप
है?
आरोप वही है, उसी में संलग्न है।
Yes, did you find out?
Annexure 3, page 23 of the read petition में
Correct. Along with the show cause notice, report is given.
शो कर order. आरोप संलग्न है मतलब 13/4/2015 my lord. The petitioner received an 21/4/2015 my lord.
आरोप संलग्न है, इसके साथ रिपोर्ट कहाँ है?
जी रिपोर्ट भी लगा हुआ है सर। क्या प्रभंजन कुमार गुप्ता लोको पायलट मुगल सराय आरोप आप दिनांक 7 को पाला के कार्य के दौरान लापरवाही पूर्वक संचित किए जाने के साथ डिलीवर वैगन लगातार 500 मीटर तक घसता हुआ पाया गया। न्यू कहें हुजूर इसमें है आरोप संलग्न।
दिस इज द चार्ज, वेयर इज द रिपोर्ट?
एनेक्चर 9 में हमारा है काउंटर एफिडेविट में
पेज 9
ज्वाइंट नोट्स ऑफ सुपरवाइजर
एनेक्सर
एनेक्चर ए पेज 9
of OA
with my counter affidavit my lord filed by
before this court.
yes my lord.
कहाँ है?
Report is given.
Report is not part of the record. Report is here, but not part of the
Report has
record.
been given to the petitioner. Then on that basis only will set aside.
That's why annexed
Page
in
23, 24, 25. Report is not there.
only joint report of supervisor my lord, senior supervisor, technical senior supervisor my lord of 5-man committee
आप
my lord.
दोषी पाए गए,
जी
ये रिपोर्ट देने में आपको क्या दिक्कत थी?
जी लगा ऑलरेडी लगा हुआ। इस प्रकार आपने रेल
Whether you were in receipt of this report or not.
No, my lord.
The joint report.
Such a report, my lord, as per the...
Whether there is any statement of yours that this report was never
No, I have
provided to you.
I have consistently denied the allegation of dragging.
The denied
And
of allegation
no, my
of,
lord,
please,
such a report has not been served upon me.
whether you have made a categorical statement that no such report was ever provided to you. आप तो hypothetical बात किए हैं कि 500 मीटर ड्रैग हो ही नहीं सकता है. Whether this report was available to you or not.
Such a report is not with my
Any
petition, my
statement
lord,
of
and was
yours?
also not served
Any-
upon me.
Any statement of yours?
My lord, my statement, the 8th line from the bottom of the typed copy, in Lecture 5 I am reading out.
Mr. Railway Council, you have to apprise by what method you have furnished a copy of the report to the petitioner.
I have I have all the petitioner have already received, my lord.
कहाँ है?
His signature was there, my lord.
इसमें
हाँ, कहाँ कॉपी है मेरा?
कहाँ है इसमें सिग्नेचर?
है हुजूर।
For the last 10 minutes we are,
3 पर देखा जाए, he already
Mr. Council,
accepted, signed and
for the
accepted.
last 10 minutes we are asking the same question. You are not able to apprise this court with one document that it has been supplied to him.
I have already supplied him, he already received,
It's already
my lord.
supplied, that is your oral
He
statement.
has already received, my lord. That is already page 23, my lord.
Page 23,
10, 20,
page
23, reach
24,
application,
page
my lord.
25. Thereafter, page 26 and page 27, this report is, where is this report?
My lord. In read petition, my lord, the charge memo.
Whether it is a statement that he has deliberately not annexed this document, it was part of the charge. Is there any statement of yours that this document was part of the charge but not annexed with
that
the?
was already all the.
Sir, where is the statement?
That was already annexed in OA petition, my lord, by the petitioner, my lord.
Sir, has he admitted that he is in receipt of the document?
He says that in OA that was annexed. He says that in the OA that was annexed. कहाँ है OA पर पेज दिखाइए?
I pray for 1 week, my lord. Yeah, 2 days, my lord. I have.
Counsel for the respondent, Railways is hereby directed to apprise this court as to whether copy of the report, joint committee report, which is the basis of allegations against the petitioner, has been provided along with the show cause notice while initiating disciplinary proceedings under Rule 11 of Railway Servants within bracket Discipline and Appeal Rules, 1968 or not. If it is furnished, in that regard, necessary document be placed on record. Joint committee report is dated 14/3/2015. List this matter after 2 weeks.
Milords, I have just received the copy of today's affidavit, Milords.
Copy of the?
Today's affidavit filed by the Union of India, Milords. In this case, I pray for 4 weeks' time, Milords, to file reply.
What is the affidavit has been filed?
They have considered case of each petitioner, Milords, and rejected their claim for regularization.
Your Lordships had ordered that if the claims be considered according to the rules, that has been done. A speaking order has been passed. Your Lordships, we brought those orders on record. दूसरा केस धरा दिया हमको. Your Lordship had ordered that if the appellants
Order dated 1/8/2022 is complied by the respondent, concerned respondent, and a copy of the same is made available to the Land Council for the petitioner. Accused of the petitioner is permitted to file rejoinder, if any, to the supplementary affidavit filed on behalf of the department respondent. List this matter after 2 weeks.
My lords. Obliged.
Serial number 16, Sanjay Kumar versus the Union of India, for the petitioner Sri Sanjay Srivastava.
My lord, on last occasion, my lord had directed to file counter affidavit, my lord, to bring on record the method of recruitment. My lord, the respondents have filed a counter affidavit. They have supplied to me. My lord, they have stated everything except for the specific direction of the court.
Yes, where is your counter affidavit? When did you file?
Filed on 14 September 2022, my lord.
Where are the document in respect of the post of driver, senior goods guard, passenger guard?
It's not specifically mentioned, my lord, senior
Huh?
good. It's not specifically mentioned senior goods guard, my lord, but there is an indication to the extent.
No, where are the rules?
It's erection number R4 and R5, my lord.
R4?
At R4 and R5, my lord.
There is no R4 and R5.
That is dated third. He's saying he has filed yesterday.
Page number 13.
No, you have filed yesterday.
Yes, my lord. We furnished a copy to the opposite party.
That is not part of our file.
Registry is hereby directed to track the additional counter affidavit stated to have been filed on behalf of the railways dash department. Release this matter next week.
Obliged, ma'am.
Serial number 17, file is not available. Serial number 18 is adjourned for next week. Serial number 19, Vijay Kant Jha versus the Union of India for the petitioner Sri Indradev Prasad.
Again, Hindi master. Again, Hindi master. बोलिए कॉपी देंगे.
May I plead, my lord? In this case, my lord, petitioner was initially appointed as a sorter assistant in the year 1969 in the erstwhile Department of Post and Telegraph. Thereafter, petitioner was absorbed under BSNL with effect from 1st of October 2000.
Sorter assistant in the year 1969.
1969.
And later on joined?
Later on, petitioner was absorbed under BSNL, wide presidential order with effect from 1st of October 2000. Thereafter, petitioner, while working as chief accounts officer ad hoc, he superannuated on 31st of January 2006. In the meantime, thereafter a policy decision has been taken by central government for time-bound promotion in the year 2007. Since petitioner was promoted on ad hoc basis as chief account officer in the year 2001 itself, so he was supposed to be promoted after 4 years, that is in 2005, for grade pay of rupees 16,000 to 20,800. 16,000 to 20,800. This grade pay. For this, even petitioner filed an OA before Central Administrative Tribunal. Earlier, earlier tribunal has directed respondent to decide the matter and accordingly representation has been made. Although respondent has not complied the order, thereafter a contempt petition has been filed.
Where do you get a right to seek a grade pay of 16,000 to 20,800?
Policy on time bound promotion, the policy decision is at page number. Policy decision is at page number 33, my lord. If I may be permitted to read, running page 33.
What is 33? 33 of what?
33 of this writ application. Annexure A2. This letter has been issued on 7th of March 2007. The subject is time-bound post-based executive promotional policy for group level officers of BSNL. A copy of time-bound post-based executive promotional policy for Group B level officers of BSNL issued by Corporate Office New Delhi memo number so-and-so, dated so-and-so is enclosed herewith for information and necessary action. As per the policy, the process of first IDA upgradation of all eligible executive of BSNL with respect to review due on 1st of October 2004, 1st of October 2005 and 1st of October 2006 is to be completed by 31st of March 2007. Accordingly, a list has been called for where authority of the petitioner department has not apprised the proper list and proper documents of the petitioner. That's why
No, on what ground your claim has been rejected?
my claim has been rejected that since I have superannuated in 2006 and I have been promoted in the year 2004 itself. So my time
No,
bound
if you are promoted to the post of Chief Accounts Officer in 2004.
that respondent is assailing. That contention has been assailed, although no any document.
No, sir, you have been promoted to the post of Chief Accounts Officer on
in the year 2001. In the year.
In 2001 on ad hoc basis.
On ad hoc basis.
Thereafter, on regular basis, you have been promoted in 2004.
I have not been promoted on regular basis.
You have not been promoted.
I have superannuated on ad hoc basis itself.
Then what is that you are saying 2004 something?
In respondent has I may be permitted to bring letter.
You retired while holding the ad hoc post of CAO.
Yeah, Chief Account Officer. I may be allowed to read the impugned order, my lord.
Where is that?
Impugned order is at page 11.
11 of?
Page 11 of this writ application. May I read, my lord?
Page number 11 is different.
Annexure 1.
That is page 12 here.
Page 11, running page of writ application.
What is the reason assigned?
Reason assigned is that last at page 14. However, in order to prevent firstly, second last paragraph may be seen.
Page 14.
14, page 14. Thus, we do not find the grant of relief in this case to be barred by period of limitation. No, first ground has been taken off limitation, and
no, we are not getting that page number 14.
Page number 14 of running page of this writ application.
Hey, running page.
Even I have filed original copy, my lord.
Page 14 के इधर This is CAT order.
Ordered OA 050 936 of 2016. After page 116, the first petition. After 116, first petition.
Oh, he is pointing out rejection by the department.
You are taking us to the order of the learned tribunal or the department?
Tribunal.
Para 6.
Yeah, para 6, my lord.
Read.
Uh, First ground that London
No,
Tribunal
it's all
has,
right, sir. Read para 6.
my lord. However, in order to prevent multiplicity of litigation, we have also looked into other merits of this case. The case of the applicant depends on the factual correctness of his claim about having been promoted to the CAOS grade in 2001. The counsel for the respondents argued that even if he was promoted ad hoc, he was later reverted by another order dated 18th of October 2001. On completion of the period of such ad hoc promotion, the counsel for the applicant denied such reversion and alleged that it amounted to only a technical break, and the applicant was continued in that capacity by further orders, that is dated 10th of December 2002 at annexure A11 page 38 of OA. Even if this claim of the applicant was to be accepted, the avowment of the respondent that he was promoted in a functional capacity on 18th of August 2004 is hard to refute. The claim of the applicants about the non-receipt of the orders dated 18/20th of August 2004 is prima facie unacceptable. He has by his own admission worked as a CAO till the date of his superannuation in 2006, and it was by way of limited period ad hoc promotion order as done earlier. If alleged by him the production of these orders would benefit his case, he should have produced them by them himself. In light of these facts, his next time-bound financial upgradation would have been due only in 2008, and thus the claim of the applicant fails on merits too.
Which is the feeder catered to the CAO?
Pardon, my lord?
Which is the feeder catered to the CAO?
Cadre is...
No, what was the post held by him before he was appointed on ad hoc basis to the post of CAO?
Senior accounts officer.
What is the pay scale?
Pay scale was, my lord?
Senior accounts officer.
Yes, senior.
It was 13,000 to 18,250. Lord, it was 13,000 to 18,250.
13,000 to 18,000.
To 250. 18,250.
What is the pay scale of CAO?
Lord, this is Lord 14,500.
14,000?
500
to
18,750.
Whether the petitioner has been given 14,500?
My lord.
Show us document.
Yes, Lord. Lord, I have got this. I have brought that, Lord.
You have his service record?
Lord, I have got the order of the promotion.
Promotion?
Ji.
Please pass on.
Lord, I am providing 2 copies for my Lord's
Yes,
kind
yes.
consideration.
Mr. Petitioner Counsel, you have not removed the defects.
My lord, I have removed the defects.
Neither the original order nor the photocopy of the order is present with the main file.
My lord, I have filed original hard copy in August itself. I have filed original 2 hard copy in this section, writ section, my lord.
In paragraph 2 of this letter, your lordship would be pleased to find, in pursuance of so and so.
No, where is the promotion order?
This is.
No, it says that the officiating promotion given to the under-mentioned officers in the grade of CAO are terminated with effect from 18/8/2004, and they are transferred and posted as a senior accounts officer.
Lord, may I read for my Lord's kind consideration? May I please, Lord? Paragraph 2 of letter dated 20th of August 2004. Paragraph 2, my Lord.
Yes.
In pursuance of BSNL OM number so and so dated 18/8/2004. This letter is at the next page, your Lord. The under mentioned senior account officers who are permanently observed in BSNL are hereby ordered to officiate on ad hoc basis in the grade of senior time scale of accounts and finance so and so in the scale of 14,500 to 18,750 with immediate effect off from the date the officer is actually assumes the charge of the post, whichever is later until further order.
Then why they are reverted back to the senior accounts officer?
He has not been reverted, and in this scale, my lord, in this scale, he has retired after completion of his tenure, my lord, on 31/1/2006. In this scale itself.
What is the material to show that he retired as a chief accounts officer in the pay scale of 14,500?
My lord, may kindly have pleasure to see at page 63 of the brief, your lord, page 63.
Page 63.
63, my lord. That is the speaking order passed by the department, my lord, in pursuance to the order of the learned tribunal, my lord, at page 63, your lordship. That is order dated 8/1/2015.
You produce his service book.
I will produce, your lordship. I will.
Prima facie, there is some confusion as to whether petitioner B.K. Jha retired as a chief accounts officer on officiating basis in the pay scale of 14,500-18,750, or while holding CAO on ad hoc basis with a lien in the post of feeder cadre senior accounts officer in the pay scale of 13,000-18,250. Therefore, it is necessary to peruse the entries made in the service book of the petitioner. Hence, counsel for the respondents are hereby directed to secure original service book of the petitioner so as to ascertain entries made. Release this matter after
Lord,
3 weeks?
3 weeks, my lord, 3 weeks.
3 weeks.
Okay. Serial number 20, Pinky Kumari versus the Union of India for the petitioner Sri Jayant Kumar Karn.
May please, your lordship. As per the order dated 4/7/2022, your lordship, the respondent have filed a supplementary counter affidavit annexing the speaking order as your lordship has directed to do so, sir, lordship.
Have you passed a speaking order?
My lord.
Where is that?
The speaking order is Annexure A, your lordship, page 8 of the supplementary counter affidavit, your lordship. Your honor will find on the last para of the page 9 as part of the specific direction of your lordship. It starts with accordingly in compliance with the Honorable CAT Patna Bench Order OA number 57050 of 870 of 2014 dated 6/5/2015. The following orders have been already issued and complied.
Where is this para 17 1 and 2 of FRSR part 1?
My lord,
On page 10, last sentence. No work, no pay.
yes, that's it.
Where is this?
Para 17 of FSR.
Para 17.1 and 17.2 of FRSR.
My lord.
What is that FRSR part 1?
That is a rule, your lordship.
You have prevented him in discharging the duties. How can you say no work, no pay principle is applicable?
My lord, because the job granted to him was erroneously, it was granted, he has not complied, he didn't possess the qualification of having the English as his primary language. He was reinstated on the court's order. We didn't prevent him. He was appointed and he was reinstated in the department just because of the court's order, your lordship. And since he was not working at that time of the period.
What was that order?
My lord.
What was that order?
It was the CAT's order, my lord.
Page 74. With all consequential benefits.
Yeah, my lord. The matter was to be decided on the all consequential benefits only, your lordship. On the last occasion, also, your lordship has asked about the consequential benefit includes the back basis or not, and it was up to deciding the matter up to the back wages on the period which he has didn't served, your lordship, and that was the period of
14 to 15.
My lord, that's it. 14 to 15, your lordship.
Where has the CAT clarified that the notional means no back wages?
That is in the CAT's order, your lordship. In CAT's order.
None appears for the petitioner. Pursuant to the order dated on 4/7/2022, the following order was passed. Concerned respondent has passed a speaking order on 22/7/2022 in extending certain service benefits of the deceased employee in the result. Petitioner Pinky Kumari, wife of a deceased employee Sri Ajit Kumar, is entitled to monetary benefits to his job. If monetary benefits have not been calculated and disbursed as on today, the same shall be calculated and disbursed in favor of Pinky Kumari, wife of the deceased employee Sri Ajit Kumar, within a period of 8 weeks from the date of receipt of this order, if it is not already settled to his term. If there is any further delay in settling the monetary benefits to petitioner Pinky Kumari, in that event she is entitled to interest at the rate of 8% per annum on all arrears amount. Further, she is entitled to litigation cost, and it has been quantified at rupees 25,000.
Litigation cost may be waived off, your lordship.
No, if you are not settling within 8 weeks.
If not settled.
Okay. My lord. कर दे रहे क्या अतुल आनंद इसमें कहा ना इसमें पिछले डेट पे भी मेरा पिछले ऑर्डर पे भी रत्नेश कुमार लिख फॉर रेस्पोंडेंट पिछले डेट पे भी छूट गया